All heat on Trump. The largest legal breakthrough in the DA's RICO coup case is a decision to get tough with alleged co-conspirators. DOJ investigators say there are at least 6 coup plotters, but only DA Willis brought the actual charges, indicting all of them, including pivotal lawyers like Giuliani, who pushed states to brazenly steal the race, and John Eastman, the architect of the coup memo, who'd been searched for criminal evidence by the feds, as you see here, who faces possible disbarment, but is now criminally charged for the first time for racketeering and efforts to get public officials to illegally steal the race. An update on his case. Today, a Georgia judge ordered a $1,000 bond for defendant Eastman. No objections from his side. Eastman's transition from a lawyer to the president to someone who needs a lawyer was foretold in those riveting January 6 hearings.
Get a great criminal defense lawyer, you're going to need it.
Now, that was a Trump White House lawyer recounting his blunt advice and warning to Eastman, who is now represented by defense lawyer Charles Burnham. You may recognize him there because he joined us before these new Georgia indictments came down. And John Eastman's lawyer, Charles Burnham, returns to the beat tonight. Thanks for coming back.
Thanks for having me back.
Absolutely. Since we last spoke, your client's charged with counts that include the RICO statute, as mentioned, which is a tough one, the violation of oath by a public officer, conspiracy to commit forgery, conspiracy to commit false statements and writings, and other filings of false documents, part of the hook there being they say they have evidence that he knew it was false. I want to give you a chance to respond to these charges here first. So what do you say to them?
Sure. I think in summary, I would say this is the Georgia indictment is more extensive than the federal indictment that, as you mentioned, named Professor Eastman as an unindicted co-conspirator. But it doesn't change the essential picture of what his role is here, which we've contended from the beginning, and we continue to contend today, was he's being unjustly criminally charged for acting as a lawyer, making aggressive and creative arguments on behalf of a client, none of which were foreclosed by the law, which is exactly what his duty was as the attorney for President Trump.
I understand that defense. Have you ever knowingly filed false materials with a court or knowingly lied to a judge about a material matter?
I certainly haven't, and neither did John Eastman. I know the overt act you're referring to there, and I think as the evidence unfolds, the picture of that is going to be markedly different than it's presented in the indictment.
Well, let's get into that. As you say, you know what I'm referring to. We'll put it up. They say they have the evidence that Eastman put it in writing, that the Trump campaign basically was making filings, the knowledge of which verified in the complaint were not accurate. I want to put that up there, as you see. And it then says this filing was one of the acts of racketeering activity. In addition, you and I discussed previously that Mr. Eastman at one point said, oh, here's the law, and then reversed and said the opposite. What is your response to their specific allegation as part of the racketeering case that he was knowingly putting forward false material?
Sure. So I'll respond as best I can within the confines of privilege. There's an old saying for trial lawyers, maybe you're familiar with it, that the ultimate move in a trial is to take the government's best evidence, or what they think is their best evidence, and turn it around and say, no, that's actually the best defense evidence. And I think that's what's going to happen with that particular overt act. As I said, I'm a little bit constrained by privilege to say, here's this email that's going to come out and this discussion happened. But in summary, what the evidence surrounding that filing is going to show is the exact opposite of what the DA thinks. In fact, it shows John Eastman and other attorneys being scrupulous to ensure that no knowingly false statements were included in legal filings, including the filing in federal court, as none were.
One of the things we discussed last time was the fact that Donald Trump lost the election. President Biden was president-elect at the time of these activities. The Electoral College had certified that. He is, of course, as you know, now president. And so if you're going to cling to some of these arguments as they get later, as the votes are certified, as the Electoral College acts, it seems to me, and I'm curious your response here in the public forum, that you have 2 problems for your client. Yes, people can make aggressive, as you call it, legal arguments, but they can't, of course, commit forgery or fraud, and they can't certainly foment an insurrection. So it seems that you have 2 issues. One, at what point does he go beyond providing professional legal services? Forgery, as mentioned, or lying to a court deliberately, or lying to the government is certainly not covered, as you know, as we know, by law. And then two, is there sort of a pseudo-delusional insanity defense? This came up earlier in the broadcast in a different context with a different person. But is your defense going to boil down to trying to convince a jury in Georgia that Mr. Eastman's arguments, which failed, they didn't, of course, prevail in the Supreme Court, arguments that he said at the time probably would lose in the Supreme Court, were based on a good faith delusion, that he believed up and through January 6th that Donald Trump had magically won a race he lost, and there was secret fraud and alien laser beams and all this other stuff. Does that mean what your best bet is to try to tell at least one or more jurors that your client, Mr. Eastman, was just really off base, to put it kindly?
I think your reference, perhaps in jest, I don't know, to a delusional insanity defense is a presage of a dynamic that I think will play out over and over again in this case, as John Eastman is being portrayed, present company excluded, but by other sources, as some kind of raving, unhinged madman. And I think what the jury and perhaps even the media is going to learn is that Dr. John Eastman is a respected academic, a grandfather, a professor with respectful relationships with liberal professors over many, many decades, and that his scholarship and his legal theories about the Constitution were aggressive, certainly controversial, all sorts of counter-arguments for them, but well thought out, based on scholarship.
Yeah, and respectfully, his parenting, which I didn't bring up, is not called into question, whether he has kids or grandkids. I mean, I get it. With a jury, you might want to humanize. Before I run out of time with you, Mr. Burnham, interesting post today online by another lawyer who's also been indicted, who has also been on this program, Ms. Jenna Ellis, who says, quote, "I was reliably informed Trump isn't funding any of us who are indicted. This has become a bigger principle than just one man. So why isn't MAGA Inc. funding everyone's defense?" Like others who have clearly done a lot for Trump, the courts and others can judge what she did. But boy, did she do a lot. She seems to be learning the hard way, like so many others, that it's a one-way thing or one-way loyalty, as I read that. So I'm curious, A, if you can tell us who's paying you for Mr. Eastman's counsel, and B, do you have any response to what co-defendant Ellis says?
I could never, with any client, I could never get into who's paying the bills and all that that's privileged, obviously, but I will just say that I would never take on a representation unless my only and sole goal was to do what's ever best for the client with absolutely no other considerations.
Respect.
And that's what I intend to do here.
And what about what Ms. Ellis is saying? She is someone who, like Mr. Eastman, did advocate all the way down the line for Trump, and she seems to be suggesting, she is saying that it's a one-way loyalty, and she's being sort of sold out.
I'm going to let Ms. Ellis speak for herself, as I would with all the other defendants. Everybody's in a different position. They all have different views, and she has her own platforms to give her views, and I'll let her do that for herself.